52049 Mukoro, M-U-K-O-R-O. Mr. Mukoro, you are the appellant, and you've asked for 20 minutes and 15 for your first. So take the podium and begin your presentation.
May you please the court, please? I'm privileged to be here. This has been my first time being in the Supreme Court of Texas building. I want to begin. This is an appeal from a judgment of the Evidentiary Panel 4-3 for the State of Texas, District Number 4 in Houston. Please take notice that on October 2nd, 2009, Appellant in Commissioner Lawyer Discipline versus John Mukoro, H0020826139, Step 2, was found to have violated Texas Disciplinary Rules of Professional Conduct Rules 1.14a, 1.14c, 5.03a, and 5.03b, and was sanctioned by suspension from the practice of law for a period of 3 years, beginning December 1st, 2009, and ending November 30th, 2012, with 1 year beginning December 1st, 2009, ending November 30th, 2010, actively served, including attorney fees for $3,360 and 15 additional hours in ethics and 12 additional hours in law practice management. Now, appellant, that is myself, have been found in violation of Rule 5013 again, Rule 5013B again, B1, and 504A for matters that arose from the same circumstances of the previous relating to bad hire of Stephen Akinobosun, who was my law clerk at that time, my office clerk at that time. And it's been sanctioned again by the suspension from the practice of law for a period of 4 years with 6 months actively served, including attorney fees for $3,750 and direct expense of $811.65. Additional hours in ethics and 12 additional hours in the law practice management and law practice monitor for the period. Justice would not be served if appellant is not given credit for time served. It would grossly be unfair to appellant to be successively punished for a violation that happened the same time and circumstances without having the benefit of the first. It does not stand right as a second sanction. The actual cost of a shutdown to my practice, the actual cost of another shutdown to my practice is more than the panel would have thought about as punishment for these violations that are reasonably remote from appellants. Appellate counsel exhibits a hateful stereotype for appellant that he's trying to validate, which is perfectly articulated on page 27 of appellate counsel's brief. Appellate counsel is purposefully omitting or mischaracterizing the evidence, including but not limited to testimonial evidence and the substance of appellant's disposition to achieve this purpose. This unfair appellant position was made worse with the presentation of the 1099, wherein a legal assistant was purported to have been compensated $154,769.98 for the year 2005. I quite agree it is a ridiculous amount to appear on a legal assistant's 1099, but there is credible explanation for that. However, such reasonable explanation for the amount made so far has fallen on deaf ears. Just for your information, for 2005, same year the 1099 was issued to Stephen, my spouse and I barely made $100,000 in combined income. Unfortunately for appellant, this amount on the 1099 has also become a weapon in appellate counsel's armament in its attempt to obstruct justice for appellant. On every opportunity appellate counsel has used this weapon to incite and inflame others involved in the adjudication process, including the 4C panel, leading to the sanctions that could not have been supported by the evidence presented at the hearing, including the now retracted sanctioned that Appellant IOTA account be monitored. This sanction was only retracted at the request of Appellate Counsel as not supported by the evidence presented. The evidence based on which this matter being adjudicated should be derivable from three sources: Appellant's deposition, Teketele's testimonial evidence, and Ms. Foster's, who was not available to testify. Neither was any testimony demanded from her, and should not include Appellate Counsel's stereotype of Appellant. However, nowhere in this body of evidence was there any smoking gun pointing directly at Appellant as a direct perpetrator of bad acts. Rather, the evidence clearly shows that Appellant is also a victim of these bad acts perpetrated by his employee, Stephen Akinibosu. This matter was only predicated based on the unfortunate circumstances Appellant found himself after victimization by Stephen Akinibosu. Appellate Counsel has also exacerbated the situation by making it what it is not in an attempt to validate and affirm his stereotype of Appellant. Appellate Counsel has done this either by purposely mischaracterizing or omitting evidence that may be favorable to Appellant to build a story that matches his stereotype of Appellant. I only hope and pray that I get justice in this level. The evidence is clear that Appellant did not commit this professional misconduct. However, Appellant is not faultless. Appellant hired Stephen Akinibosu without thoroughly checking his background. These happenings have proven that Appellant hiring practice in hiring Stephen the time he did was flawed. Evidence that were available, Appellant, of course, my deposition was available. That's where the issue of the 1099 for $154,000 arose. The issue that I opened my Dallas office in 2005 also arose from my deposition. The apparent large amount of money presumed to be paid to a law office assistant confused and threw off focus the facts, despite Appellant's testimonial evidence that the amount was not for compensation for work done, but include repayment for other sundry loans advanced to Appellant and spouse, but okay, I said that before. This evidence of the 1099 continuously threw off the panel because it was indeed a large amount, and it threw them off from looking at the evidence and detailing sanctions that supported the evidence. Tetekele's testimonial evidence she did not testify that he met or have ever met Appellant. Tetekele met with Stephen at a McDonald's restaurant. Stephen had access to law office business cards and contracts. Settlement check for $40,000 was written in another party's name, not Appellant's name. No direct evidence to the fact that testimony Appellant in fact had the file in my office. File was concealed from Appellant by Stephen Akinibosu. Of course, Foster did not testify. Record shows that she never met Appellant. No direct evidence to the fact that testimony of Appellant in fact was in the file in my office. There's no evidence to such. Now, permit me to correct some of these omission and mischaracterization in evidence in Appellate's brief. On page 2 of Appellate's brief, the first paragraph, it says, Mukoro wanted Akinibosu to make the firm's presence known in Dallas and believes that Akinibosu may have brought cases with him from his former firm, as Akinibosu received referrals from other firms. That is a mischaracterization of what I had said in my deposition. The paragraph that follows, it says, somewhere that it says, although Mukoro testified that he told Akinibosu that he had to give approval before any piece of work could be accepted by the firm, the files for the Dallas cases were kept in Dallas, and Mukoro had no system by which to keep track of files and clients in that office. According to Mukoro, he would only give a cursory look at the files on his trips to Dallas. Because his relationship with Akinibosu, Mukoro did not think it was necessary to develop a system to track the Dallas files. In retrospect, Mukoro wishes he had done that. That's a mischaracterization. I had files in my office. I kept track of my files. But I thought he was asking me about an electronic system. I do have files in my office. Very quickly on page 4, she was originally represented, the case of Tete Kelly was injured in an automobile accident in 2007. She was originally represented by an attorney named Carl Gaines.
Mr. Mukoro, can you slow down just a tad?
Okay.
I think the court reporter might be having a little trouble understanding.
Thank you very much.
Thank you.
I'm on page 4, the second paragraph.
Thank you.
Sigereda Teketele was injured in an automobile accident in 2007. She was originally represented by attorney Carl Gaines, but then Akini Bosun called and told her that Gaines was suffering from a brain tumor and that he, Akini Bosun, wanted the case. On January 26th, Tete Kelly met with Akini Bosun. Akini Bosun gave Tete Kelly his business card. He met with Akini Bosun at a Burger King. He was not in my office. Okay, the last paragraph on the same page, near 2008, Tete Kelly learned that her claim had been settled. She tried to call Akini Bosun but could not reach him. So she called Mukoro. Mukoro, who had been alerted at this situation by Tete Kelly's brother, had begun investigation, confirmed that the settlement to her, that Deep South Insurance Company had paid $30,000 and Safeco Insurance Company had paid $10,000. Mukoro also told her that her settlement of her claim was not his problem. Teketele later came to learn that Akini Bosun had forged her name in order to obtain the settlement money. Checks that have been mentioned here were not made to the Mukoro law firm. This is another mischaracterization. The checks were made to Daly and Associate law firm, so there's no way I could have had access to those checks. There's no way I knew about this account, but the Appellate Council omitted that from the facts. Neither Akini Bosun or Mukoro, this is another mischaracterization, neither Akini Bosun or Mukoro ever sent Teketele any part of the $40,000 received in settlement of her claim. The checks did not come to me. I couldn't have sent her those checks because the checks was in another law firm's name. But which Appellate Council knows this, but of course, he left it out and just to mischaracterize it. Okay, Tete Kelly hired another attorney to represent her, and in the end, she received $77,500 from Deep South and $10,000 from Safeco. Tete Kelly also sued Mukoro and filed a criminal complaint against Akini Bosun. Okay. Yes, I also reported, Mukoro made reports to Financial Crime Department in Dallas, and warrant was issued for the arrest of Akini Bosun at this particular time. The warrant still exists. But, of course, the Appellate Council mischaracterizes it to achieve his objective. The checks are available. If you look at, on the record, evidence, CFLD Exhibit 23 to 28 clearly states that. Another mischaracterization. Due to Akini Bosun's percentage compensation arrangement, he received $154,000 in employee compensation from Mukoro firm for the year 2005. That's indeed a mischaracterization of my deposition. I didn't say I was paying him on a percentage basis, but that could be looked at.
About a minute and a half.
I have a minute and a half, please. Thank you very much. Also on page 12, halfway down that page, although Mukoro had only run his solo practice in Houston for merely a year, he opened an office in Dallas put Akini Bosun in charge. Akini Bosun ran the Dallas office with minimal supervision from Mukoro. The files for the Dallas cases were kept in Dallas with no system which Mukoro could keep track. That's a mischaracterization. Those clients were not signed up by me. Those clients were minimal. It said I had minimal supervision over Steven. I flew from Houston to Dallas 3 times a week to have supervision over my office. The sanctions reads that I permitted Akini Bosun to engage in conduct that have been a violation. I did not permit him to do that. I wouldn't have permitted him if the original petition for this matter states that John did not know about it when his client was signed up. Again, the checks that from the insurance company for one of the clients were written to Daly and Associate. They were never written to John Mukoro. Is my time up?
You've got 10 seconds
Okay.
until your rebuttal time.
On page 17, the allegation that Mukoro violated 5.04a by sharing and promised to share legal fees with Akinibosun was brought to the attention of the Office of Chief Disciplinary by John Mukoro. That was purportedly gotten from my deposition. My deposition was, I didn't testify to that, that's not what I said, but he mischaracterizes to suit his purpose. Every time he has the opportunity, he keeps waves this bloody shed just to get the attention of the panel, and that's exactly what he's going to do here today. He's going to wave that again and distract the panel from giving me justice.
Thank you, and you reserve your 5 minutes. We'll call you back.
Thanks.
Thank you very much. Mr. Bursch.
May it please the board. I'm going to postpone my anticipated opening because I think I can deal most directly with this by responding to what Mr. Mukoro has just said. On page 63 of the transcript from the hearing, the original evidentiary hearing in the case, we were reading extended excerpts from Mr. Mukoro's deposition. And the question that was read, the last part of the question was, did you know at any one time all the files and the clients that were pending there in the Dallas office? Did you have some sort of system like that? And Mr. Mukoro's answer, quote, no, I didn't have any system like that, close quote. So there was nothing in the question about a computer system versus some other kind of system. On the next page, page 64, at lines 23 and 24, Mr. Mukoro says, quote, in retrospect, I wish I had done that, close quote. And then on page 67, the question was, quote, so although you operated under the name of Mukoro and Associates in each city really was operating as independent entities then, with fees coming in, expenses being paid, bank accounts being maintained, and quote on the question. And then the answer is, quote, that was the idea, close quote. Then further down on that page, page 67, the question was, quote, do you have any idea at all how many clients that you signed up through the Dallas office? Answer, no. Question, what about during the 3 years that the Dallas office was open? Do you have any idea? Answer, I wasn't keeping up with that, close quote. Then he goes on to talk about how the Dallas office was operated. Page 78, talking about the fact that he drafted some pleadings, his non-lawyer legal assistant, Stephen Akinibosun, drafted some, his secretary drafted some. And then on page 79, we get into the issue of the fact that he had authorized them to sign his name to pleadings and file them, and he thought that was an acceptable thing to do. There are many, many more excuse me, examples that I could cite. The thrust of Mr. Mukoro's argument today appears to be largely directed at me for allegedly misstating the record and in doing things to inflame the panel. The record speaks for itself. We quote at length from the record in the appellee's brief, often with direct quotes. There has been no misstatement of the record. Mr. Mukoro, both in his brief and in his argument today, raises various issues, but there is really only one issue in his appeal, and that is his effort to escape responsibility for his actions. Mr. Mukoro, barely 1 year into the practice of law, established a separate office in Dallas, separate and apart from his Houston office, and essentially set up his non-lawyer legal assistant, Stephen Akini-Boson, to practice law independently. Mr. Mukoro occasionally made trips up to Dallas and had some rough idea what was going on, but he was not supervising that office and running that office in a way that a lawyer should do. That was the first misconduct on the part of Mr. Mukoro in his failure to supervise Mr. Akini-Boson. The second misconduct, of course, was sharing fees with Mr. Akini-Boson. And again, there is no misstatement, there is no misrepresentation. Looking at page 94 of Mr. Mukoro's deposition transcript, which was read into the evidence in the case, beginning on page 23, the question, quote, "And when that happened, when a settlement came in, how was it that you calculated how much Mr. Akini-Boson would be paid?" Answer, quote, "Well, I gave him a percentage of what came in after all the expenses were paid. Then I'll give him a percentage of what comes in the office," close quote, ending on page 95. And then over on page 96, question, quote, "For example, if this was a friend of his that he brought into the firm and then he did a lot of work, he might get a higher percentage of the fee. Whereas if it was somebody that he didn't know and he did less work on, then he might get a lower percentage?" Answer, quote, "Yes, pretty much, close quote. So there's no misrepresentation of the record, and the evidence is clear and the evidence is strong. Of course, we're dealing here with the substantial evidence standard, and all we need to show is that there was a reasonable basis for the panel's decision to find that he had violated the three rules. If there's more than a scintilla of evidence, we've met our burden, and obviously there's far more than a scintilla of evidence, and clearly a reasonable basis for the decision that panel 4-3 made to find that Mr. Mukoro had violated the three rules and then to impose the sanction that they imposed. Not all of the evidence was from Mr. Mukoro's own mouth, but a considerable amount of it was. Mr. Mukoro, a lawyer, a litigator, submitted himself to a deposition. Questions were asked. Answers were given. On November 14, 2011, Mr. Mukoro has been trying to run away from his deposition answers ever since, but he can't do it because it's in the record. So the panel had clear evidence and clear reason to make the rulings that they made. It's interesting, actually, and sort of a side issue, because we base our case on the evidence. We would submit, as we indicated in the brief, we could win the case based simply on the fact that Mr. Mukoro did not challenge the third and fourth findings of fact that the panel handed down regarding his employment of Mr. Akini-Boson and his failure to make reasonable efforts to ensure that Mr. Akini-Boson's conduct was compatible with Mr. Mukoro's professional obligations. Mr. Mukoro did not even challenge those findings in his brief. Mr. Mukoro did not challenge in his brief the holding that he violated Rule 5.03a. And finally, he did not challenge the finding in the judgment that any one of the rule violations was sufficient to support the imposition of the partially probated suspension. So on that basis alone, just the technical appellate briefing requirements, we would submit that the judgment must be affirmed. But really we prefer to talk about the evidence because the evidence is so strong. And I've already read from the deposition excerpts that completely put to rest any concern that there have been misrepresentations about what Mr. Mukoro has said. And to drill down to the essence of it in terms of what he did and how he allowed his legal assistant to do things that would have been violations for himself, There are two cases we're dealing with here, the Nidra Foster case and the Sidiguera Ticatelli case. With Ms. Foster, what Mr. Akini-Boson did was sign her up, handle the case for 2 years without Mr. Mukoro knowing anything about it, taking her to a deposition, participating in a mediation, and then, when a trial setting was handed down, completely abandoning it. So that was neglect if a lawyer had been handling it that way. That's a Rule 1.01b1 violation, and that is imputed then to Mr. Mukoro because that was his legal assistant who was doing that. Then similarly with Ms. Ticatelli, there Mr. Akini-Boson signed up the case and in very short order, in the matter of just a few months, settled her claims with 2 different insurance companies for a total of $40,000 and took the money without any of it going to Ms. Ticatelli. Again, if the attorney had done that, a clear violation of Rule 1.14b. So those are the underlying actions, the rule violations that we would have held against the attorney, but Mr. Mukoro has to take responsibility for them. Mr. Mukoro, in his argument, raises various straw men. We're never claiming that Mr. Mukoro took the $40,000. We're not claiming that. Mr. Akini-Boson was the criminal in this, and criminal authorities are attempting to deal with him. That's not what we're about here, but it's the fact that it all happened because of what Mr. Mukoro did. Mr. Mukoro, barely having started his own law practice, wanted to expand, wanted to branch out, wanted more business out of Dallas, and that's why all this came to be, and that's why we say that Mr. Mukoro must be held to account. The Steptoe case that Mr. Mukoro talks about was separate and yet related. Yes, Mr. Akini-Boson was involved with that case, but it was a different arrangement because at that time, in that case, Mr. Mukoro was aware of what was going on. He was the one handling the case. There was some money that came into the firm, and then Mr. Akini-Boson did not handle that money correctly. That case had been filed more than a year earlier and was resolved just a few months after the grievances were filed by Ms. Foster and Ms. Ticatelli. That's why they were handled separately, and they deal with different actions. The mere fact that Mr. Akini-Boson is involved with both does not give Mr. Mukoro a pass on this. There was one element of wrongdoing with a client who was harmed that was dealt with in the Steptoe judgment. Here we have 2 other purported clients of the firm who were harmed, different in time, different in type of misconduct on Mr. Mukoro's part, where here he had no idea what was going on because of his completely cavalier attitude toward his Dallas office. As far as the sanctions are concerned, we believe it is appropriate. The original sanction in the Steptoe case was for the 3 years, partially probated with 1 year active. Now in this case, Panel 4-3 decided upon 4 years, partially probated, 6 months active. We had an original evidentiary hearing just on the misconduct phase that lasted approximately 6 hours. A couple of months later, we had a hearing just in the sanctions phase that lasted approximately 3 hours. A judgment was signed. Mr. Mukoro's attorney, he had an attorney at the time, filed a motion to modify that judgment. We had a 3rd hearing to discuss these various issues. After those 3 hearings, after first issuing an original judgment and then a modified judgment, this was the panel's considered opinion. And they state in the opinion that they considered the factors in Rule 2.18, and they did. The briefing and the argument regarding the motion to modify really represented an entirely new sanctions hearing. This judgment was more highly considered and more precisely considered by the panel than the average judgment. And this was the decision that they made. So the standard, of course, is whether there was an abuse of discretion. Was the sanction either so light or so severe to show that it did not use proper discretion? We would submit that that is clearly not the case, that this judgment involving Mr. Akini-Boson is 1 year longer in terms of the overall length, but 6 months shorter in terms of the active suspension than the Steptoe judgment had been. I can't tell you exactly why they came to that determination, but it reflects a precise evaluation on the part of the members of the panel as to what was appropriate in this case. As far as some of Mr. Mukoro's other arguments are concerned, he refers in his argument, as he had in his brief, to this issue of the 1099 form. Again, this is really a straw man. This was a passing matter that came in. It provided some context, really, for the money that was being earned by Mr. Kenny Boson, but it is not central to what we're talking about here. Whether he earned 6 figures or 5 figures or 4 figures, the essence of it is that Mr. Mukoro clearly admitted that he was sharing fees with Mr. Kenny Boson. That's how Mr. Kenny Boson was paid. Mr. Mukoro referred several times in his argument to the fact that I have supposedly stereotyped him. I'm not sure exactly what that even means, other than the fact that, yes, we did pursue this again. We thought it was appropriate to pursue because additional grievances were received and additional harm had been done. When Mr. Mukoro says that there's no smoking gun pointed to him, well, characterizations like that are hard to deal with, but I would consider his deposition testimony to be, if not a smoking gun, then a finger pointed directly at him through his own words as to his conduct. In conclusion, the Commission would respectfully request that the Board affirm the judgment of Evidentiary Panel 4-3. Thank you very much.
Does the Board have any questions for Mr. Bursch? I have 2, but I don't want to steal anyone's thunder if he has a question. One, I haven't heard either of you mention, but it's in, I've seen it in the petition and various things, the argument about the alleged violations being outside the 4-year statute. Can you speak to that?
Certainly. I'd be pleased to. This was not a violation that was contained in the grievances that were filed. The 2 grievances were filed in March and May of 2009, and the case went through the normal process till we came up to November 14, 2011, when I took Mr. Mukoro's deposition. And as I've discussed, the questioning that came out, and I've read some of that, it was at that time, because of his candid statements in response to my questions, that the Commission became aware for the first time that Mr. Mukoro had paid Mr. Kenny Boson by sharing legal fees with him. So we added that to our petition and sought the finding of a rule violation. Because of Rule 15.06, that was in effect at the time. Of course, there's been a change since then. Under the current Rule 15.06 that went into effect just last year, that does not govern this case. It says that a respondent can be held to account for misconduct that occurred less than 4 years before the grievance was filed. The prior version of 15.06, which governs this case, indicates that the crucial period is when the misconduct was brought to the attention of the Chief Disciplinary Counsel. So here, what it means is that any misconduct that occurred after November 14th of 2007 is misconduct that could serve as the basis of a finding of a rule violation. Go back 4 years from November 14, 2011. So then we look into the record and the evidence as to the relationship between Mr. Mukoro and Mr. Kenny Boson. And it's undisputed in the record that Mr. Kenny Boson was employed by Mr. Mukoro and working for Mr. Mukoro at least through April of 2008. Mr. Mukoro concedes that. In fact, in his brief, his counsel conceded it during the hearing. There's some dispute actually as to what happened after April of 2008 because Mr. Kenny Boson was not formally terminated until August of 2008. But there's no question Mr. Kenny Boson was working for Mr. Mukoro at least until April of 2008. So what that means is that we have a period of time from November 14, 2007 through April of 2008 when Mr. Kenny Boson was working for Mr. Mukoro and still being compensated in the way that Mr. Mukoro indicated in his answer to my question. And that's why we believe there's no problem with the limitations question.
Okay. My other quick question, just I'd like kind of to hear your thoughts on, I totally understand the concept of fee splitting, and I'm sure the board does, but one of the examples you gave about one of the questions in Mr. Mukoro's deposition was if you knew somebody and you worked harder on the case, he might get more than if he didn't work so hard on something, might get less. I understand that if, you know, basically the arrangement was when we get a fee, you're getting 10% of our third or whatever, fine. But how is the examples that you gave different from, say, the way most of us decide at the end of a year or something, the profits, we give Christmas bonuses or whatever to our, and those might be determined by this person worked pretty hard, you know, and that's what determines and drives that. How would that sort of arrangement, getting paid bonuses essentially based on the work done in a case, be different from that other situation?
I think at times it could get to be a fine line between the two, but I think for the most part in most law firms it's easily distinguished, because with what you're asking in your question, at the end of a year, after all the cases have come in and all of the money has been received and the bills have been paid, or at least calculated as to how many bills need to be paid, the owners or the partners in the firm see what their overall financial standing is. And they paid everyone a salary during the year, presumably, and so they make a decision, either for a holiday bonus or for some other reason, we're going to give some extra money. I think that's specifically allowed in the rules, but that is not a sharing of a fee. That is simply compensating your employees on an overall basis.
Can I interrupt there just to make a twist on it? My understanding was that this employee received no salary and got paid at the end. My question would be, if he had received a salary, albeit a small one, and then at the end of the case, depending on how hard he worked on it, he got a bonus out of whatever was paid on that case, would that have been acceptable?
I think it would be, I think if somebody could have a salary and there could still be a fee-sharing arrangement, that would not be acceptable. We obviously have to look at the particular facts of the situation. I think, both in answer to your question and the previous question, it's the matter of, are we looking at this on a case-by-case basis? Money comes in August. We're not looking at the end of the year. And in August, we say, now we take our third. We had a $90,000 settlement, and our third is $30,000. What's going to be done with that? And if the attorney is handing out some portion of that, 10, 20, 30, 50% out of that fee, and that's the only compensation the employee is receiving, then we would submit that's a clear case of fee sharing, and that's what the testimony is, because the man was not being paid anything else. Even if he had been paid a minimal, say, $500 a month, something out of his pocket, but he was still receiving that extra amount, we would still say that.
At what point would you say his salary was sufficient that he could get a bonus out of that $30,000 and it wouldn't be fee splitting?
Well, I think that's the problem. And of course, I think somebody who was really trying to compensate an employee in that manner and was aware of Rule 5.04a and was really trying to cover his tracks could probably do a job, make an effort that would make our job more difficult. Because if on every check he wrote bonus, and if he dressed it up in some way, it might be hard to prove that. His intent might be fee sharing. Whether we could prove it, I'm not sure that we could, because bonuses are acceptable and fee sharing is not. I don't think we have that in this case, because, to be honest, based on the dialogue between Mr. Mukoro and me in the deposition, I don't think Mr. Mukoro was aware of Rule 5.04a, or he would not have answered the questions as candidly as he did. He was fee sharing, and he admitted it to me, and without the artifice that we're talking about.
So you would make a distinction, at least with the facts of this case, that if bonuses are getting paid sort of in conjunction or coincidentally as fees come in for a particular case, that's something different, that maybe even a firm mid-year is having a good year mid-year and they really want to reward their hardworking
Yes.
clients, and they've had a couple of good cases come in and say, you know, I think we're going to give everybody a mid-year bonus because they've been working hard.
That's exactly right. And frankly, sometimes when I read legal publications and some of the firms that are very famous and very profitable, there are stories like that where things are done and bonuses are paid. But I think that, again, the owners of the firm are looking at the overall financial structure of the firm and deciding whether they can afford to do something. Some firms make more money, some firms are more generous. Whereas here, this is the arrangement. From boss to employee, this is how you're going to get paid. Bring me cases. And again, part of the context for this is how this firm, the Dallas office, was set up in the first place. Mr. Mukoro hired Mr. Kenny Boson because of the contacts he already had. It was like hiring another lawyer or taking on a lawyer as a partner. He had contacts in Dallas, both generally and in the particular community there, and Mr. Mukoro wanted to make use of those contacts and brought it in and have this second law office. So really that was implicit in the very arrangement. And you've got the chance to really make some money here. Do work, bring in your cases, and we'll share the fees.
Did that lead to any other questions?
I have one. It's relevant then in determining whether additional payment is bonus or fee splitting the source of the business. If this is a case that a non-lawyer brings into the firm and then handles it, then gets part of it, it's more likely to be a fee splitting than bonus based on the overall operation of the business that does not include participation of the non-lawyer.
I think it would be more likely, and I think it could be a difficult situation. Let's say we have a firm where everyone is trying to do everything on the up and up. The employees are being paid a salary. There's no fee sharing going on. It's certainly conceivable that an employee in the firm, because of a relative who's injured in a car accident or some other reason, would bring a piece of business to the firm. I think and if it turns out to be successful, it's conceivable that there could be some sort of bonus. I think the people in that situation need to be very careful as they enter into the situation. So the employee would know up front, there is nothing guaranteed for you. You are not a lawyer in this firm. You are not set up with your own book of business. I appreciate what you brought to us. We're going to work on it. We make no promises to you whatsoever as to what's going to happen. You may not receive an extra penny from this. Again, in stark contrast to the situation with Mr. Mukoro and Mr. Kenny Boson.
How can it ever be ethical to compensate a non-lawyer for bringing in business to the firm for which that person then receives remuneration, whatever you call it?
No, I don't think it would be. I'm saying that if the case that's brought in contributes to the overall success of the firm so that a bonus can be paid to however they do bonuses, but I think that's my point, and perhaps I didn't express it well. I think that the attorney to whom that piece of business is tendered would need to be very clear to the non-lawyer employee, you're not entitled to a piece of this. You're nothing. We're going to take it, we're going to work it, and we'll see what happens in the overall firm. I think that's what they would need to be very careful about.
Any other questions from the board? Thank you. Mr. Mukoro, you can come up for your 5 minutes of rebuttal. And before I do that, though, for the court reporter's benefit, the other person that's being referred to quite often, the spelling of that name, Kenny Boson, is Akinnibousun.
Thank you.
Thank you. Mr. Mukoro.
Thank you. I will just spend 1 minute of my time to make another point here. On page 27 of the Appellant's brief, it said Mukoro had a delayed entry, second paragraph, into practice of law after his career in chemistry and his eagerness, because I have an advanced degree in chemistry, and his eagerness to become as successful as possible, as soon as possible, led him to open his Dallas office. So when he took over this case, he knew exactly where he was going. I have an advanced degree in chemistry, having graduated from Sam Houston, Huntsville, and Texas Tech, Lubbock, and University of Houston. I worked in the chemical industries for about 12 years. I decided to go to law school. I didn't go to law school to be as rich as possible. This is a clear evidence that counsel's stereotype that has been trying to validate in this matter. The filing system he talked about, he asked me, did I have a filing system? I have files. Of course I have a filing system. How many clients did I sign up in my office in Dallas? I thought he was asking me at that instant, do you know how many clients you signed up in Dallas? That was the question he asked me. I said, no. No, I don't know how many clients I signed up. At this time, this is about 2 years later. Then a fee split. I just believe the statute of limitation keeps that 1099 out of this matter in the sense that I only paid Steve in 2005. There was no other evidence that Steve got paid beyond 2005. The 1099 was in 2005. That was it. There was no evidence. There is no evidence in record that shows that I continued to pay Steve. So I think that should have come in. In businesses that happens in my office as a lawyer, I'm responsible for that. I take responsibility for that. But if my employee is a thief and he goes out in a Burger King and signs a contract with my name, he has access to my letterhead, my business card. He goes outside the Burger King and signs a contract, and the check is made payable to him when it happens. I don't think I should be held responsible for that. There's a limit to which I can supervise my employee. So that was what happened in both cases. Those files, I wasn't aware of them. But when step two matter happened, the first one that happened, that's when I realized that there may be a problem here. So that's when I shut things down, and that's when I found out that these other issues were out there. So I started dealing with them. So why would I be punished for cases that could have been resolved by the bar at the same time, and I'm punished just once for all of that? They are related. They happened. They arose from the same circumstances. My hiring of Stephen, they happened at the same time. But however, I realized probably they were too far apart in time for them to be handled. But I still believe that I cannot be punished twice for the same things that happened, arose from the same circumstances. I could be given credit for time served. That's what I'm asking for. And I think the panel abused the discretion when they sanctioned me without that. They gave me sanctions that the evidence does not support.
When you say credit for time served, are you talking about the first sanction?
The first sanction. I was sanctioned heavily for that. I accepted responsibility, but however, at the same time, these things happened at the same time. If it was close enough for the bar, I'm sure they would have done it at the same time, but I guess it wasn't close enough. But now, I just finished serving my first time. I'm going to another one without having benefit of the first time. I think it's unfair for this to stand as a second violation in my professional record. I ask that the panel review the sanctions and give me credit for time saved. Thank you very much.
Thank you, Mr. Mukoro. Anybody have any other questions?
When you say credit for time served, what would you do with a 1 year active? You want the 6 to go away?
6 to go away, 6 months to go away, because that will involve shutting me down. I shut down for 1 year. I came back and picking up my clients in my community. Now to be shut down again for these matters that could have been done at the same time. And most importantly, the issue of fee splitting. I, frankly speaking, did not split fee. He was just wanted to go that way to make it look as bad as he could. I'm asking that the time off, the time off should be, the 6 should go away. I will have to shut my office for 6 months and break my contracts. It has a devastating effect on myself and my family. Thank you very much.
Thank you.
Yes, Mr. Gerwitz has a question.
If you've already been sanctioned once that you said you accepted responsibility for that, did I understand you correctly? It was.
Yeah,
but this time you say you really weren't at fault, that this is a misunderstanding? Or,
that's what I'm saying.
But assuming that there is sufficient evidence to find a violation virtually of the same conduct, at what point do you think it would indicate that this is happening more often than should occur, that reflects on whether or not you ought to receive a license to practice law at all?
Okay.
How many times is enough?
Okay, that's the problem with this, because this is going to be a second time. But however, this matter happened just one time at the same time when Steve was in my office. That's when it happened. If this becomes a second sanction on me, I think it's unfair because I could have been sanctioned. It's just happened once in my Dallas office. I've never had any problem in my Houston office because that's where my primary office. Never had any problem. But in my Dallas office, because I had wrongfully hired somebody, that's what I'm guilty of, hiring somebody who is a thief that I did not know. The bar was aware of it. They knew Steve has had a lot of record with the bar. In the case of Fuller, Steve also stole from him, but I did not know that. I'm also a victim.
But you really weren't interested in knowing that. As long as he was bringing in business, fees were being generated. Why would you want to know?
Oh, I would be.
It's a good deal.
I would be. No, that's not the case. That's the way this has been characterized. But that's not the case. I just went to Dallas to work for people. I have family members in Dallas. That's where I went there for. Steve is somebody I met in law school. I met him in law school innocently, and we became friends. He lived in Dallas. I thought, he's about my age. I thought we could just do business together. That's what I thought. I hired him for my Dallas office. I go to Dallas about 3 times a week.
Can I ask you one quick question that just occurred to me in the statement by counsel and see how candid it is? Did you realize when you hired him that you could not split fees with?
Certainly I did.
You understood that from
I understood that perfectly.
Okay, thank you.
Any other questions of either Mr. Mukoro or Mr. Bursch? Thank you very much.
Thank
we
you.
will take this under advisement and inform you of our decision.
Thank you.
We're going to take